Thought I had asked this, but I might not have. For the medical conditions that you have complained of during the time that you were speaking with the doctors and they said that they didn't give you the treatments that you were requesting, did they ever offer that they would have a doctor from the outside perform the treatment for you?
No.
I don't have anything further.
It's Dugan cross-examination.
Yes, sir.
All right, so the incident in the shower, after you let the inmate know that you did not like what she was doing by telling her to stop, did she ever try that again?
No.
And that inmate's no longer, or you didn't disclose the name of that inmate, but you did tell the investigator that that inmate is no longer in jail with you, right?
She's no longer there. She left shortly after that.
Okay. As far as the arm twist incident from October of 2024, you said you reported that in February of 2025?
Yes.
Okay. And you wouldn't give the name, you said you wouldn't give the name of her to the investigator either. Okay.
No.
But you do know that if you would give her name, that instead of you being separated from the pod, she could be separated from you and you could be back with the general population.
Yeah, but she's not the only one that could hurt me. That's why I wouldn't do it. She had a half a dozen girls that came up to me.
Was there ever any physical violence by her or anyone she's friends with after that October
No.
24 incident?
No, that was it. That's it.
And by being in solitary confinement, does it give you an opportunity to have a quieter space where you can prepare for trial?
Well, I guess it would be a quiet space if I could get some sleep and I would be able to concentrate on what I'm supposed to do. Yes, that would be helpful.
Do you also get in-person visits with your attorney in jail?
I do.
Okay, and when that happens, are you in a room alone with him or her or both?
Yes.
Okay.
Yes.
And y'all are able to have conversations then that are private?
Yes.
For the sciatic nerve, in December of 2024, were you offered a solumedrol steroid injection for that pain that you declined?
I am going to object to the use of the medical records by the state based on a prior objection.
Dugan, do you have an ability to show that these records were not a part of what was obtained by Investigator Newland that is still disputed?
No, these are part of what was obtained by Investigator Newland. But my understanding is that the defense would have opened the door to this by asking her about all of these times she was seen by medical staff and what basically was not done for her.
As to that, I will permit the witness to answer. You may answer, Ms. Adelson.
Could you ask me one more time?
Yes, ma'am. For the sciatic pain that radiates down your right leg, were you offered a solumedrol, a steroid injection, and then after that, a medrol, so a steroid dose pack that you declined until you were able to speak with your physician?
No. I told her that in the past I had gotten a steroid injection in my spine, and she said, we don't do that. I could offer you, and it was a medrol dose pack, I think.
A solumedrol injection?
I can offer you that, but we don't do that. And having had sciatica twice in my lifetime, I know what's been done each time, and I know that worked. And so she said, we can't do that. We don't offer that. You would need to see a specialist for that.
Okay. I'm going to show you this page. I'm looking at the encounter from December 13th, 2024 at 3:22 p.m. What does it say? Offered patient a solumedrol injection and then starting tomorrow a medrol dose pack. Patient requested decline until she can speak with her physician.
I don't know what a solumedrol injection, but she told me they don't give steroidal injections in the spine. She says we don't do that. And I don't recall her offering an injection. I do remember she said I could give you other medication. But I've been there. I've done that. I know what happens with sciatica and I know what needs to be done. That's not going to be the answer.
For your arm and shoulder pain, isn't it true that you reported you had mild pain in your left arm and
No,
shoulder?
I
this
heard
month?
that gentleman say that before. I couldn't believe it. I told her that I had severe burning pain down the outer part of my arm. I never used the word mild pain. So I don't know where they got that from, but that's not what I said.
Okay. I'm going to show you the encounter from February 3rd, 2025 at 2:29 p.m. Under musculoskeletal, does it say positive for left upper extremity limited ROM range of motion, comma, mild pain?
That's what it says, but that's not what I said. No way is that pain mild.
And so that's just what the doctor would have written down, but you're saying that's not what you told
I
the doctor.
I did, had that been given to me and I read it and I had to sign it, I would say I never said this. But I'm telling you, I never said mild pain.
Okay.
It's shooting hot pain down my arm.
For that injury, you did have an X-ray, and they did go over that X-ray with you and let you know that there was no fracture or
There
dislocation.
was no fracture. That's what she told me. I didn't think it was a fracture.
Or dislocation of your shoulder or arm.
No, there's just pain.
And they also went over your chest X-ray results with you to let you know that your chest X-ray appeared clear.
Yes.
Okay. You ultimately received the Band-Aid and Neosporin for the cut on your elbow.
Yes, I got that on Saturday. When did I get that? On Monday.
Okay, so within a day or two of the cut occurring.
Yes.
And you said that if you are given a bond, you will reside in Tallahassee, you will follow court orders. But when you were afraid of being arrested right after Charlie Adelson's trial, isn't it true that you hoped that you could get to the airport before you were arrested?
I wasn't afraid of being arrested.
What were you trying to get to the airport in time for? In that jail
My
cell?
husband and I were literally shocked and traumatized at what had happened to Charlie. And he said, we need to just get some peace. We need to catch our breath. We're going to go away somewhere. And I thought it was a good idea because I couldn't think straight. I really couldn't think straight. I was so upset, and so was he. And it was his idea. He said, sweetheart, let's go just get away. We're going to just get away somewhere so we can have some time to think.
Okay, so your testimony is that you weren't trying to go to Vietnam because you wouldn't be able to be extradited from there.
So my husband actually had said, we've been to Vietnam before. We with friends. We were on vacation, and it really was like a place of peace. And so he said, if we go to a non-extradition country, then if the law enforcement decided that they wanted to arrest you or me, whatever, both, he said, we won't be sitting in a foreign prison waiting months to go back. We can buy a ticket and we can go home. And my understanding was that I could go home and I could turn myself in if that's what they wanted.
Okay. But you were hoping to make it out of America in time before you were arrested, right?
I wanted to get away. He wanted to get away. That's what we wanted to do. And we spoke to our attorneys. I asked them. They said there's no pending. We purposely called them to make sure it was legal to do it. And they said there's no, what were their words? There's no pending charges and there's no warrant. So we want to go. And so I thought you ask your attorneys and they tell you that. I'm going.
But Dan did tell you, as you say in the jail call, that knowing what they're thinking up there, I don't know if you'll make it out in time. I really don't. that he said you might, or you might get to the airport and they'll stop you. It could happen.
That's what he said.
Right. So you went to the airport knowing that it could happen. They could stop you at the airport. You could end up being arrested.
That's what Dan said.
Right. And when you were looking at places to go those couple of days after Charlie Adelson's trial, you were specifically looking, though, for countries that did not have extradition with the U.S.
For the reason I just told you.
Right. And the reason that you're saying that you were looking for countries with no extradition was so that you could get back faster in order to be arrested in the U.S.
No, that's not what I said. It's because, I don't know, maybe we watch too much TV or too many movies, but I've seen movies where people are stuck in like third world prisons and waiting and waiting and waiting. And my feeling was, this is not what we want to happen. If the state says they want us to come back, we'll buy a ticket, we'll come back on our own terms. We don't have to be sitting in a jail somewhere. We'll come back home and turn ourselves in.
Couldn't you have done that no matter what country you went to?
No.
No?
You
You couldn't have found out that you had a warrant for your arrest and come back if there was an extradition
Well,
policy?
not if they would, I'm not in law enforcement, but it appears that they would notify law enforcement in that country and then they could hold you in a jail for God knows how long. And I didn't want that to happen. So he said, well, that's why we'll do it this way, honey. That way, if they do notify us, so we get a phone call from our attorney or from law enforcement, then we'll buy a ticket, we'll go home.
Okay.
And so it would have been on our terms. That was the point. That was the reason that he thought that was a good idea.
And your
You
testimony.
continue, Ms. Dugan. We are over time. If you please can get to your most pertinent questions.
Yes, sir. I guess your testimony ultimately, though, is that you were not trying to go to a country with no extradition because you were trying to avoid being held accountable for this charge. That's your testimony?
I didn't do this.
Okay.
Being held accountable for this is not what happened.
Being arrested for this case.
Being arrested?
Right. That was not what you were trying to avoid by trying to go to a non-extradition country.
We were trying to get our heads on straight and just breathe.
That's all that happened to you.
Any redirect examination for Mrs. Adelson?
Just one question, Judge.
You may proceed.
The testimony was you were offered an X-ray. You were never offered an MRI for your shoulder, were you?
No.
Thank you.
Hi, this is Ed, not AI, with commentary about Wednesday's hearing in the Florida versus Donna Adelson case. For the first time ever, by the way, Harvey Adelson attended a hearing in the case. He was well-dressed, wearing a suit. He sat at the gallery behind the defense table. Donna looked often at him, and he occasionally blew kisses at her. It was a sad sight to see, but whether or not Donna was actually involved in the murder, this sad situation is the result of Donna and Harvey's actions during Wendy's divorce from Dan Markel. There can be no doubt about that. Guilty or not, she would not be in jail had it not been for Donna and Harvey's, assuming the emails were really from both, toxic interference in the divorce proceedings, and even before that, in the relationship and marriage between Dan and Wendy. All right, let's get back to the hearing. First, we will talk about the motion to suppress. In essence, Donna's lawyers want to suppress the jail call where Charlie dropped off mid-call and Donna put the phone down but did not hang up. And the recording continued and captured Donna talking to other people at her home, making statements that could be used against her at trial. Attorney Joshua Zellman handled this portion of the hearing and tried to establish that Donna withdrew her consent when she thought that the call had dropped, and that therefore there was no consent for the continuing recording, and the recording should be suppressed. The state, on the other hand, argues that it did nothing wrong, that the recording was accidental, and that the accident was on Donna's part, her failure to hang up the call, her mistaken assumption that the call, and therefore the recording, had stopped. Zellman failed to call to the witness stand anyone from the phone company that actually records these calls. Instead, he called the state attorney's investigator, Jason Newland. But Newland is smart, and he negated Zellman's efforts to get him to admit some wrongdoing on the part of the system. Zellman hoped for evidence to support a good argument that the state-hired recording company set up the system to continue recording even after the person in jail dropped off the call, supposedly in the hopes of continuing to record the participant in the call who was not in jail for whatever reason. It could be that a person from the phone company was not called because there's nothing there. It seems that the system reasonably continues recording even when the call drops on one end, because often connections are bad, and a call may be dropped only momentarily, such as while a person is driving through a zone with a bad connection. If any time there was a bad connection issue, the recording would stop and the company would drop the call. This likely would be bad for the system. However, Mr. Zellman did score a point on this issue. Without calling Charles Adelson to the stand, he was able to elicit testimony from investigator Newland that the system showed that while the system was recording Donna, Charles had been desperately trying to call back his mom. This suggests that this was not a situation where the call connection was temporarily bad, but that Charles' side of the call had definitely ended, presuming that he was using the same phone or tablet to attempt to call his mom back. Nevertheless, the fact that there was no testimony from Charles Adelson or from the jail call's telephone company weakened the defense's arguments of some wrongdoing on the part of the state. So, the bottom line with respect to the motion to suppress is that it does not appear that there is a good reason to suppress the recording. Suppression is meant to discourage misconduct by the state. There's no evidence that the state did anything wrong. Prosecutor Sarah Dugan also made excellent legal arguments in support of her position that the other courts have allowed accidental recordings to be admitted into evidence. There were a few other failures by the defense with respect to the motion, such as eliciting evidence and making points that were weak. For example, as Judge Everett stated, it is pretty clear that there is some expectation of privacy in one's home. Zellman introduced testimony that Donna was supposedly consulting with her lawyer, but as any good lawyer knows, there is no attorney-client privilege if you allow third parties to hear your conversation with your lawyer, and the evidence was that Donna's husband and the lawyer's husband were both present during the conversation. Overall, although it seems unfair to allow a recording that Donna had no intention to allow the state to record to be used as evidence, the recording only happened because of her own mistake in not ensuring that the phone was properly hung up. She was aware that the calls are recorded, and she should have been more careful with her phone. Even though she proved that subjectively she had an expectation of privacy and that the recording was over, it seems unreasonable to conclude that her expectation of privacy was reasonable after she failed to assure that she also hung up the phone. Judge Everett announced that he would read the cases cited by the parties before he issued his ruling. But if we go just by common sense, it seems that the state has the stronger position on these issues. However, to us, the bigger surprise on this issue is that Part 2 of the hearing may have made this entire issue moot, at least for the most part. You see, the defense allowed both issues to be heard together and decided to move forward with the bond hearing, even though the judge did not rule on the spot with respect to the motion to suppress. During the bond portion of the hearing, which we will discuss on a separate video, Donna testified about the details of the conversation that the defense is trying to suppress. Since her testimony at the Arthur hearing can be used against Donna, it seems that the motion to suppress the jail call is now a moot point. In this video, we discuss the second part of the hearing involving the bond Arthur hearing issues, concentrating on the evidence presented by the defense. In the final video, we will discuss the evidence presented by the prosecution and the arguments of counsel for each side. First, the defense presented evidence to demonstrate releasing Donna on bond would be appropriate. Former Circuit Court Judge Jackie Fulford of the defense team handled this portion of the hearing. Fulford put her on the stand to discuss Donna's awful medical experience while in jail. Before we go into the details, let's consider a couple of issues. First, it should be noted that Donna has not yet been convicted of a crime. Under our system of justice, she is presumed innocent until convicted. That does not mean that she deserves to be free until her trial and conviction, of course. When a person is arrested for a crime, he or she is usually able to get out on bond while awaiting trial. There are many exceptions: danger to the community, flight risk, failure to comply with release conditions, etc. Otherwise, a defendant is usually able to get out, unless he or she has no means to secure a bond to bail out of jail. For the most serious crimes, such as first-degree murder, it is more rare that a defendant will be allowed out on bond. It happens occasionally, as we have previously noted about the Adam Frash case, but it is rare. With more serious crimes, even before a conviction happens, the interest in the safety of the community and the need to ensure that the defendant will face justice rather than disappear means that the system is designed to keep those accused of more serious crimes locked up while they await trial. Of course, not everyone accused of a serious crime ends up being found guilty. There are times when the state charged the wrong person. There are other times when the state may have charged the correct person, but the state was unable to convince a jury of guilt beyond a reasonable doubt, and therefore the jury voted not guilty as to that person. There are times when the state only proves a lesser offense, an offense that should have permitted the defendant to be out on bond. Thus, there are situations where innocent people, or people against whom the state does not have enough evidence to convict of the charges that were filed, sit in jail for a long time awaiting trial. In a jail, as opposed to a prison, you have people serving time for lesser offenses, misdemeanors. You have prisoners who return back to jail for testimony or similar circumstances, and you have those accused of crimes who have not yet been convicted of anything. Donna fits in the last category. She has not been convicted of anything. Thus, her complaints about jail conditions probably should be given more weight than a complaint by someone who has been convicted of a crime, because pretrial detention is not supposed to be punishment. The entire purpose of the Arthur hearing is to determine, in lay terms, whether the state can clearly show to the judge that the defendant is indeed super likely to be convicted, that the evidence is so strong that there is virtually no doubt that this person is going to prison. The state has to meet this heavy burden because being in jail is no walk in the park. It obviously has significant effects on one's life, freedom, income, health, well-being, happiness, etc. Even if the state shows this to be the case, that conviction is nearly assured, the court does have the discretion to grant bond. If the state does not meet this burden, then the defendant must be given the opportunity to bail out, unless the state can show that there are other considerations why bond should be denied: risk to the community, flight risk, etc. With this context, let us examine what happened at Donna's hearing on her motion for bond, the Arthur hearing. The defense only presented the testimony of Donna Adelson. Donna was called to the witness stand. She looked much heavier than in prior appearances. Donna Adelson presented pitiful testimony about her health problems and how being in jail has impeded her right to appropriate health care. Before we address her testimony, a couple of side notes. Donna was caught at the Miami International Airport about to leave on a one-way ticket to a third world country. I wonder what type of medical care she would have been able to obtain there in Vietnam. More on this later. On top of that, at prior trials, we have all seen Donna's emails to Wendy. where she proposes to Wendy various schemes to try to convince Dan to let her move to Miami, and even suggestions that Wendy had to give, quote, the performance of her lifetime, unquote, at the hearing on her motion for permission to move with her kids in order to win the war against Dan Markel. Therefore, the court has heard evidence about Donna not having a high level of integrity or respect for the judicial system, and about Donna suggesting to her daughter that she had to give a performance for the divorce court judge. Anyway, back to her testimony. Donna complained of several medical issues. She also complained about the food, her inability to sleep due to the noise and for other reasons, lack of time outside, and lack of opportunity to exercise. Furthermore, she complained of not feeling safe at jail. Let's break down the details. Direct examination. Donna complained of a recent exacerbation of sciatic pain, for which she claims she needs a steroid shot. She was offered a medical mattress, only to then be told that this facility does not have them. She was only offered Tylenol, which does not work. She also was at first allowed to use a double mattress, and this helped for some time. But since she was moved to confinement, protective custody, she is no longer allowed to use a double mattress. Therefore, she is experiencing a lot of pain. Cross-examination. She was offered a steroid shot and medications, which she refused to take until she consulted with her doctor. Left arm pain from being assaulted at the jail, very painful. Cross. Received x-ray, redirect, no MRI done. Difficulties with hearing, due to having a narrow ear canal and the facility not being able to clear out her wax in a way that will work. She claims that the treatment option she was offered does not work, so she refused it. And this makes it hard for her to hear under certain conditions. This also leads her to get into trouble when guards think she's not following instructions, but she can't hear them. She had a minor accident and suffered a small cut in her arm and was unable to receive prompt and adequate help, and instead was forced to use toilet paper and sanitary pads to deal with the bleeding. Cross. Eventually got Band-Aid. She gained 1/3 of her body weight in weight due to poor nutrition, mostly carbs, virtually no protein. Cross. She is able to order eye care packages, canteen, gets tuna, etc. She has been experiencing a decline in health, including difficulty breathing, which could be a signal of heart issues, by the way. Cross. X-ray of the chest was okay. Oxygen levels okay. Fulford then switched to examining Donna about other issues. First, Donna described 2 assaults while in jail. The first was sexual in nature, a woman running her finger through the back of Donna's body while Donna was in the shower. Donna tearfully described the incident. Cross. The woman stopped and no longer tried anything with Donna and is no longer at the jail. Second, Donna explained how another inmate physically assaulted her while Donna was brushing her teeth. The woman, jailmate, forcefully twisted one of Donna's arms behind her back and threatened her that if she did not purchase certain items for her, Donna would be attacked and would lose her teeth. Donna claims that as a result, she told her husband to start adding certain items that Donna disliked, but that the other inmate requested to her eye care packages. She then got the items the woman wanted to that woman through the help of other friends of that woman. Donna admitted that she did not report the matter to jail authorities because of fear of retaliation, noting her understanding that there is a code of silence in the jail and that if she broke it, she would be in danger. Donna was then put in protective custody where her life is miserable. Cross. Dugan confirmed that if Donna reported the incident, the jail could take action by removing the offending inmate. Donna replied that there were others helping that jailmate. Dugan got her to admit that regardless, there have been no other incidents involving injury or assault. On cross-examination, Sarah Dugan scored other points in addition to the above. The best part of the cross-examination was Sarah Dugan getting Donna to discuss her efforts to flee the country. During that part of the cross-examination, Sarah Dugan even asked her about a portion of the information revealed on the call that the defense is trying to suppress, and I believe that this may have waived the defense's objection and opened the door for the use of that evidence given the lack of objection. The explanations Donna offered were quite ridiculous. She blamed her husband for deciding to go on a trip to clear their minds, and she said that she verified with her lawyers whether it was legal to flee to another country. Why would you check with your lawyers if you're just going somewhere to clear your minds? She indicated that the reason for going to Vietnam in particular, a non-extradition country, was based on her desire not to spend time in a third world country jail if, while on such a trip, charges were filed and Florida sought extradition. They did not want to get stuck in a, quote, third world country jail, unquote, in an extradition country for months, which, of course, begs the question, why travel to a non-extradition country in the first place? Why travel outside of the USA, for that matter, where the medical care that she needs would be easier for her to get? Why not find a peaceful place in the USA, or at a minimum, in a foreign first world country, with jails more adequate for her needs? Instead of searching for non-extradition countries, why was she not searching for the countries with the best jail conditions? LOL. Sarah Dugan also presented two quick witnesses for the state. One was a jail person who testified that Donna refused to identify her attacker, that Donna was then given the option of being moved to another pod, but that Donna chose to go into protective custody instead. Sarah's final witness on the bond issue was also a worker at the jail to discuss how an assault at the jail would be handled. The person testified that there is a system in place for jailmates to submit complaints and that Donna had never complained about extortion or assaults until she made the complaints this month on February 3rd. The defense did not do any cross and could have used cross as an opportunity to use leading questions to suggest to the court that there is, for example, such a code of silence among jailmates. All right. In the next video, we will discuss the evidence the state offered on the Arthur hearing issues to meet its high burden of showing a sure-thing conviction, and the arguments from each side made or missed on these issues. Until next time, Ed, not AI, Deep Dive True Crime. Part 3. The final part of our discussion about the most recent hearing in the Donna Adelson case regarding the motion to suppress and regarding the motion for bond. First, one more piece of evidence entered by the defense, a request that Judge Everett take judicial notice of the fact that Dr. Adam Frash was granted bond in his first-degree murder case regarding the murder of Samira Frash. That point is interesting, because former Judge Fulford had, in a sense, a role in indirectly helping Adam Frash obtain bond. We're not going into much detail on that here, but in part thanks for her absence from the bench during her legal troubles, several local lawyers took advantage of the lack of oversight and found a way to get approval through substitute judges for a deal that gave the $1 million life insurance benefit on the life of Samira Frash to her killer, Adam Frash. And surprisingly, once he got paid within days, he was allowed to bond out, and the lawyers who testified at the hearing failed to tell the judge in the criminal case that Adam had gotten significant funds from Samira's life insurance policy in contravention of the Florida Slayer statute. She was not involved directly, but her absence from the bench enabled those who helped the killer profit from murder. But it is true that Adam was let out. He waited over a year at home, and then was tried and convicted. He's now serving a life sentence. Anyway, prosecutor Sarah Dugan, in her effort to prove that the state has met its burden of showing a near certain conviction, the, quote, proof evident, presumption great, unquote, standard, offered the following evidence. Exhibit 1, probable cause affidavit for Donna Adelson, admitted. Exhibit 2, transcripts from Charles Adelson's trial, admitted. Exhibit 3, Corbett slides with analysis of Donna Adelson travel for the night of July 18, 2014, the night after the shooting, admitted. Exhibit 4, November 7th jail call, motion to suppress pending, objection based on motion to suppress. Exhibit 5, transcript of call, motion to suppress pending, objection based on motion to suppress. Exhibit 6, chat with Vietnam visa on WhatsApp, admitted. Exhibit 7, chat on WhatsApp between Charles Adelson and Donna Adelson in 2016 musing about possible explanations for why Sigfredo Garcia and Luis Rivera might have killed Dan Markel without mention of extortion, admitted. Exhibit 8, letter from Markel family with their wishes on the bond issue. See Judy's channel, AA Legal Focus. Judy has a video about the letter. Now let's discuss the argument. First, Sarah Dugan made an argument about the Arthur hearing standard. The argument was good, but there were a few glaring omissions. First, Sarah argued that the most relevant portions of Charles Adelson's trial that help prove that the state met its high burden under the Arthur case are the following. From Exhibit 2, transcripts of Charles Adelson's trial. There are 4. A, Donna had a motive to kill Dan Markel. Emails to Wendy during the divorce about Dan Markel, with suggestions on how to defeat Dan Markel and strategy to get Wendy and the kids to move to South Florida. B, checks for thousands of dollars from Adelson Institute written to Magbonawa after the murder and signed by Donna Adelson when Magbonawa did not work for the Adelsons. C, Magbonawa's testimony about her being the middle woman between Charles Adelson and the hitmen. In other words, that there was no extortion. D, Magbonawa's testimony about the night of the shooting, that Charles gave her money at his home, and that she learned that night that Charles' parents had just been at the home and her understanding that Donna Adelson had washed the money and that the money was damp. Main omissions. Charles Adelson's testimony about his mom's knowledge about the supposed extortion back in 2014. When combined with Exhibit 7, this equals bad news for Donna. Transfer of Lexus to Magbonawa. The, quote, it is about the two of us, unquote, statement from Donna to Charles Adelson on the first call after the bump operation. June Umchinda's testimony about Donna's statements against interest when discussing the murder of Dan Markel. From Exhibit 3, Corbett's analysis, Dugan argued that the analysis shows that Donna Adelson's phone records, text plus cell tower analysis, are consistent with Donna spending over 1 hour by Charles Adelson's house and being consistent with her spending about 30 minutes at his house when he arrived. And that could be consistent with Magbonawa's testimony that she understood that Donna dropped off the cash. This is perhaps the most speculative portion of the evidence. There is a good argument to be made that it does not pass the so-called, quote, stacking of inferences, unquote, test. From Exhibit 4, the jail call, Dugan discusses the portion of the call that describes her conversation with Dan Rashbaum, which supports the inference that Donna was trying to flee the prosecution, as the two were discussing the possibility of charges being filed against her and the possibility that she would be stopped at the airport. Furthermore, the discussions about a non-extradition country to go to. From Exhibit 6, chat about Vietnam visa. Showing urgency in trying to leave the country right after Charles was convicted, including indication that she wants a longer visa, 90 days, mentions getting nervous as she keeps waiting for the visa, etc. From Exhibit 7, the WhatsApp conversation obtained in 2023 about a conversation between Donna and Charles in 2016, where Charles was workshopping ideas about the possible motive of the murder after Sigfredo was arrested, and Charles writes that maybe the killer was a coke dealer, and maybe Dan Markel was buying drugs from him, and no mention is made about the supposed extortion, which was Charles Adelson's defense at trial. Finally, she mentions the letter from the Markels about their position on the bond issue. There was no mention of any significant piece of evidence from Robert Adelson, which suggests that the supposed admissions that Donna made to him are not harmful. Sarah Dugan argued that the state met its burden on the Arthur standard based on the totality of evidence in this case, but then followed up with much weaker arguments that hurt her presentation. These weaker arguments included that the state has met its burden, its Arthur burden, with respect to all other defendants in this case. Those are her words. This is a weak argument because the court is only considering the evidence against Donna, not the evidence against the other defendants. That, quote, all of the other defendants were held in custody until trial, unquote. Again, not really that relevant other than on the point that the existence of the conspiracy to commit the murder existed and that there was significant proof against the other defendants of their participation in the conspiracy and the murder. She made a good point, however, that none of those prior defendants had tried to flee, as opposed to Donna, who did. She also made a good argument that even if the state did not meet the Arthur burden, the judge should exercise his discretion to deny bond because Donna is absolutely a flight risk, more than ever, because now she's been charged and she is facing a life sentence. As to the bond arguments, Sarah Dugan argued that all of Donna's medical complaints have been addressed and that she had been treated and saw a doctor within 2 days of each request, that the accident injury was minimal and could have happened outside jail, and she eventually got an antibiotic cream and a Band-Aid. That with respect to Donna's breathing issues, she was evaluated and treated and an X-ray, and the X-ray was negative. That the jail has medical staff to provide treatment for medical needs in the jail and to reach a specialist or a hospital as necessary. That as to Donna's complaints about jail being too loud and the food being bad, Donna is not at the Four Seasons, and that all of Donna's necessities are being met, and Donna has a way to ask for necessary help in the future. Sarah also argued that Donna has access to doctors faster than most of us outside jail. As for the assault issues, the jail administrators have their hands tied because Donna is refusing to provide the identity of her alleged attacker, so their options for resolving the issue are limited. Sarah also argued that Donna was given options and chose to move to protective custody. Overall, Sarah Dugan argued the court should keep Donna on a no-bond status because Donna is safe in jail and because doing so will guarantee Donna's presence at trial. Jackie Fulford presented counter-arguments for Donna, and she did a decent job. She started with the obvious point that the case against Donna is different than the case against the other defendants. She argued that the evidence against Donna, as listed by Sarah Dugan herself, is insufficient for the state to meet its heavy burden. She focused on some of the more speculative evidence that Sarah Dugan mentioned in her presentation, such as Corbett's report showing that cell and tower records could be consistent with Donna stopping by the house on her way to Tallahassee on the night of the shooting, that those records corroborate Magbanawah's testimony. We agree overall that the evidence against Donna, at least as listed by Sarah Dugan at the hearing, is not as overwhelming as the evidence against the prior defendants. It is quite possible that Judge Everett will find that the state did not meet its Arthur burden of proof. However, we totally disagree with Jackie Fulford's argument that the state's entire case rests on speculation. On the bond issues, Jackie made a totality of the circumstances argument to suggest that all of the issues Donna is facing at the jail, combined with her age, 75, combined with her weight gain, the decline of her health, Her hearing difficulties, her breathing difficulties, her lack of sleep, etc., all prevent Donna from fully preparing to testify in her case. Yes, you heard right. Unsurprisingly, Donna will likely testify at her own trial. She also argued that the jail could not protect Donna while she was in the general population because there are no guards or cameras in the bathroom shower areas where the incidents allegedly occurred. Thus, Miss Fulford argued that if Donna rats out who attacked her, that jailmate's friend could attack Donna. There was a moment when Jackie Fulford veered off into a rant about why Donna Adelson had not been attempting to flee the country. That was the weakest portion of her argument because the story Donna told is quite incredulous. Miss Fulford made matters worse by trying to insert testimony that had not been entered into evidence. Suggestions that the prosecutor's office had assured a close family friend of Donna's that there was no warrant and that, therefore, Donna could leave the country. When the court challenged her about whether this was evidence or argument, Miss Fulford first agreed that it was argument, but then doubled down and said that the state attorney's office knows that she was not fleeing the country. Jackie then returned to better points. Donna is presumed innocent. She's not supposed to be punished yet, and based on the totality of her circumstances at the jail, Donna is being punished. Her health is declining, and it will be difficult to prepare her to testify at a trial in which her entire life is on the line. Jackie finished strong, saying that Donna is willing to be outside, but closely monitored under the most stringent conditions the court would impose, and that this is a necessity for Donna to be able to prepare for a trial in a community where she has already been adjudged guilty as the mafia mother who had ordered a hit on her own former son-in-law. We won't predict what is going to happen, but we will point out that Judge Everett is a good man with a great heart, so in spite of the fact that much of what Donna testified to lacked credibility, in our opinion, she has a chance with Judge Everett, even though it is quite obvious that Donna was leaving the country to avoid prosecution for Dan Markel's murder. Judge Everett, however, may also have concerns about Donna wanting to depart this world voluntarily, although this issue was not discussed at all at the hearing. One final point. Steph the Sleuth heard Donna's testimony and found it amusing that Donna Adelson, rather than saying what her weight was before and what her weight is now, used a percentage of change of weight, that Donna gained 1/3 of her body weight. All right. Thanks for watching Ed Talk, not AI Talk. Until next time, deep dive true crime. We will monitor the docket, and we will let you know as soon as we know how Judge Everett rules on the motion to suppress. We will be back soon with commentary about the bond hearing. From all this, Donna's defense strategy is very predictable. She would prefer to be out on bond, of course. If she's out on bond, we would be surprised if the trial happens in June of this year. Some emergency situation is likely to arise that will delay the trial. If she's denied bond, however, the case is more likely to go to trial in June. The strategy will be the same. Donna plans to testify and give the performance of her lifetime. Donna will give more unbelievable explanations, but she does not have to explain away as much as Charlie had to. She has to explain away the checks. She has to explain away attempting to flee the country. If she's out on bond, she will be happy if at least one juror takes pity on her and votes not guilty, causing a mistrial. If she is in jail while waiting for trial, she will want a full defense verdict, a full not guilty. It's a tall order, but if she gives the performance of a lifetime, who knows, maybe she'll pull it off. Given the performance at the hearing, it seems unlikely. She has a lot of work to do between now and the moment she takes the stand at trial. We certainly look forward to watching and covering this trial, if it ever happens. Ed Talk, not AI Talk, deep dive, true crime.
Thanks for watching and supporting us. It is thanks to your continued support that we keep bringing you cases like this one. Keep in mind that we have expanded our channel to include many types of content, from talk shows and interview shows to deep dives in the files of criminal cases. Until next time, this is Tracy and I'm signing off from Atlanta. Deep Dive True Crime, Mentor Lawyer Justice Network, True Crime Locomotive.